Edward Dixon.
This courtroom session is anything but ordinary. From illegal weapons to high-speed police chases, from felony drug busts to judges exploding with rage. Today's docket is pure chaos, and Judge Fleischer is having none of it. We've got Edward Dixon flying through Harris County at 58 miles per hour in a 35, evading cops for miles, armed with a firearm and drugs in his car. Nicholas Johnson shows up with a pocket full of pills and a criminal history that reads like a rap sheet from a Netflix docuseries. And then there's the wild DWI case that forces the judge to unleash one of his most heated rants yet. But here's the kicker. This isn't just legal drama. This is raw human conflict, where one bad decision can wreck your entire life. Stay tuned, because Judge Fleischer isn't just handing out rulings today, he's delivering verbal body slams. Would you survive a session like this? Let's find out.
Mr. Dixon, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Please don't say anything.
Judge Fleischer wastes no time setting the tone, stern, sharp, and deadly serious. The moment Dixon steps up, the judge lists everything on the table: an unlawful weapon charge, a potential year in jail, and $4,000 in fines. What's fascinating here is the way Judge Fleischer blends procedure with pressure. He reminds Dixon of his rights, but there's an edge in his voice, a warning that this isn't just another checkbox process. This is real. The stakes are sky high, and you can almost feel the weight sink in on Dixon. Question for you: if you were facing a year behind bars for an unlawful weapon charge, would you stand calm or crack under the pressure?
Yes, Your Honor, on May 20th, 2024 in Harris County, Texas, officers observed a vehicle traveling 58 miles per hour in a 35 mile per hour zone and attempted to do a traffic stop. The vehicle evades for 2 miles over 5 minutes, driving through a retention pond before getting stuck. The driver, defendant, stated he had a firearm inside the vehicle and that he evaded because he was scared.
2 miles. 5 minutes. A retention pond. Dixon's decision to run instead of pull over sets off a chain reaction he couldn't control. Not only did officers recover a firearm, but they also found 6.2 grams of marijuana in his vehicle. Here's the real kicker. Legally, the firearm plus marijuana combo takes this case from bad to potentially catastrophic. Prosecutors often argue this pairing shows intent or heightened recklessness. Judge Fleischer knows this, and you can tell he's already framing Dixon's bond conditions around public safety concerns. Viewers, be honest. In Dixon's shoes, would you have stopped immediately or panicked and floored it?
Officers recovered the firearm and 6.2 grams of marijuana from inside the vehicle.
Mr. Dixon, I'm going to find that there's probable cause to go forward with your case. Do you have a valid Texas driver license, sir?
Yes, sir.
Can you run his license, please? You have valid liability insurance in your name. Before you drive, I want to see proof of it.
Yes, sir.
Because I'm making it the condition of your bond not to drive without a Texas driver license and liability insurance in your name. I'm also ordering you as a condition of your bond not to be in possession of any weapons as well. You were given a PR bond. You're now also charged with a felony. Do not pick up any new cases. Otherwise, I will revoke this bond and I'm going to make it high. You will not get any more PR bonds. How old are you?
This is where Judge Fleischer's style shines. Firm control, zero tolerance. Dixon doesn't just get a free pass. His PR bond, which lets him walk without paying upfront bail, comes with strings tighter than ever. No driving without a valid Texas license. Must show proof of insurance. No weapons of any kind. Break any of these, and the judge promises to slam him with a high bond next time. This is classic judicial strategy. Offer a lifeline, but make it razor thin. Would you risk breaking those conditions, knowing one slip could land you back in jail instantly?
What do you do for a living?
Zolo, Your Honor.
Prior to you driving, I want to see proof. How much money do you make a month, sir? How much? And who do you live with?
Okay.
we're gonna reset your case to give you time to hire a lawyer, sir. So I'm gonna have you go to Victoria. We're gonna have you sign a reset. After that, we're gonna create bond conditions for you. We'll have you sign the bond conditions, then we'll let you go. When you come back, please have a lawyer, sir.
There's no driving, Your Honor?
No driving without Texas driver's license and liability insurance, and then no weapons, please.
All right, case 15, Johnson.
We'll wait for you to do it, Kevin. So. Johnson. Okay. Mr. Johnson, you're charged with possession of a controlled substance. You're facing up to a year in jail and or a $4,000 fine.
Next up, Nicholas Johnson, and this one spirals fast. When cops find Johnson meeting up with a Prius, sneaking items under his shirt and hopping into a car, the red flags practically wave themselves. Add in multiple white pills and a criminal history involving aggravated assault and firearm charges, and suddenly this isn't a small possession case. Here's where the judge's tone shifts. He's not just scolding Johnson, he's practically laying out a roadmap for self-destruction if Johnson doesn't change course. Quick legal nugget, with Johnson's priors, this case could escalate beyond simple possession into habitual offender territory, which carries heavier sentences. Would you believe Johnson can turn things around, or is he locked into a cycle at this point?
We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir.
On May 20th, 2024, officers conducted a traffic stop near 11540 block of Westheimer Road, Harris County, Texas. After observing the defendant meet with occupants of a white Chrysler 200 and then go back inside the apartment building, the defendant came back outside, walking and concealing something under his shirt as he got into the rear passenger side of the vehicle. Officers identified the male as Nicholas Johnson, wanted fugitive from an investigation. Upon approaching the vehicle, officers observed the defendant in the front passenger seat and the suspect in the Frike or Roran, he was in the back seat. Upon detaining the defendant, officer observed a large bulge in his front and left pocket and retrieved a pill bottle containing multiple white pills. Defendant stated that the pills were tramadol, 4.8 grams. Criminal history, felony terroristic threat, SBI aggravated assault with a deadly weapon, was convicted.
This is the critical evidence drop. Those pills, allegedly trazodone, but without prescription proof, are the backbone of the case. From a legal standpoint, this is where defense and prosecution diverge. Prosecution's angle: Johnson possessed controlled substances without authorization, slam dunk case. Defense angle: if Johnson can prove prescription or dispute identification, he has leverage. But here's the drama: with his past convictions, judges and juries are less forgiving. That baggage always shadows your defense strategy. Audience poll: should prior convictions matter this much in current cases, or should every trial start clean?
August 26, 2021, of the lesser charge, 4 days. Felony possession of a weapon, August 26, 21. It was dismissed because of the previous charge, convicted on another charge. Attempted possession of a firearm, felony possession of a weapon, 7/6/16. He was convicted, 10 months in state jail, felony.
My problem is though, is that they're going and they get wind of him because of another fugitive, right?
No, he was a fugitive.
Oh, Mr. Johnson was a fugitive.
That's according
Don't say
to,
anything. Please, you have the right to remain silent. Exercise that right. Anything you say, they're going to sit there type. You'll have a lawyer that'll go to bat on your behalf, and then you guys can make an argument. Okay. So he was the fugitive, though,
according to, that's what I'm reading.
because I thought you said it was someone else.
No, Nicholas Johnson. He was the one.
Okay, Mr. Johnson, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond. Don't pick up any new cases. I don't want to have to put you in jail. Just don't. What do you do for a living, Mr. Johnson?
I'm in between jobs right now. I just lost my job at a car wash.
What were you doing?
At a car wash.
So how do you eat now? When did you lose your job?
Like 2 weeks ago. It was a week ago. this situation, and that's what I meant.
Talk about the case.
Okay.
I only want to know, how do you survive? How do you get money? How do you eat? How do you pay for rent?
In between jobs right now, I stay with my brother.
You need a lawyer to represent you. How's that going to happen? You need to get a job, a full-time legitimate job. Why is it fair that the citizens of Harris County get to pay for you to get a lawyer for you when you do nothing all day? No.
How bad was not too long ago. I got shot a year and a half ago.
What's happening when you got shot?
Wrong place, wrong.
It's a rhetorical question, Mr. Johnson, but when you hang with dogs, you get fleas. I want you to get a job. I'm now making that a condition of your bond as well. You understand?
And here comes one of Judge Fleischer's most controversial moves, ordering Johnson to get a job as part of his bond conditions. Legally, judges can impose lifestyle-based conditions if they relate to public safety or flight risk. But critics argue this toes the line. Is unemployment really a danger to society? Fleischer's reasoning is clear though. Idle hands, bad decisions. He's seen too many defendants spiral when they've got too much time and too little structure. Question to you, do you agree with Fleischer's approach here, or is this overreach?
We're going to give you a reset now. I want you to go get a job and then come back and then we'll see about getting a lawyer. No more bumming around doing nothing. You understand? So I'm resetting this case for 2 weeks. When you come back, I want to see what you've done to get a job, putting in applications. I'm telling you, Amazon will hire anyone with 3 legs and a partial heartbeat. Go to Amazon. I'm telling you, they hire everyone. They need more people. You understand?
Judge Fleischer delivers one of his most viral-worthy lines yet, telling Johnson to just go to Amazon because they'll hire anyone with 3 legs and a partial heartbeat is brutal, yes, but it's strategic drama. Clips like this explode on social media because they're raw, quotable, and relatable. But beneath the theatrics lies real frustration. Fleischer's seen defendant after defendant refusing stable jobs, then returning to court again and again. Here's my take. The judge isn't mocking unemployment. He's calling out excuses. Would this tough love approach motivate you or push you further away from change?
No drugs, no alcohol, and get a job. I'm going to randomly test you, Mr. Johnson. If I find that you're using, I'm going to put you in jail. Understand?
Random drug testing as a bond condition isn't just standard, it's powerful leverage. Johnson now lives under constant uncertainty. Every phone call, every random test could determine whether he sleeps at home or behind bars. Legally, this forces compliance. Psychologically, it creates constant tension which can break defendants who aren't serious about staying clean. This is where courtroom drama meets personal turning points. Johnson's either about to turn his life around or spiral back into the system. What do you think? Will he make it? Or are we watching a future repeat offender?
So don't worry about it. I'm going to have Anthony take it.
Your Honor, I just want to clarity. It's not clear. It just says that they was positively identified, and it's not clear if they're talking about Mr. Johnson or the other individual, because he does have a felony case. Mr. O'Rourke. So I'm not saying.
That's what I was trying to tell you.
Talking to the judge. I'm saying. So I just want to make that clear for the record.
If you get a job and it doesn't pay, I'm happy to give you a lawyer. You understand? But I want you to start working, earn your keep. Do you have any kids? What are you doing to support those kids?
Kids are taken care of.
How? You don't work?
My kids are taken care of. So.
The road to hell is paved with good intentions, Mr. Johnson. Kids don't eat with good intentions. Come on.
Chavez, right this way.
See, I'm inundated today.
Hey,
I got
I
you.
come back to like this.
Oh, it ain't mine.
Fleming,
Literally just when I started, he's still inside.
she's here.
Yes.
What do you want
I
to do?
instructed her, we're gonna withdraw from her case.
Come up.
Yeah.
She said she will have the past due balance paid later, this week. I've been told by my supervising attorney to withdraw if she gets the.
Just
past-
because you wouldn't withdraw doesn't mean I'm going to grant it. You know what I mean?
That's what I told her as well.
Court's majority.
What's the last name on this?
Kizzy,
Kizzy,
Okay.
yes.
he's not happy with you. Why?
Because I was late on some payment, so I still have to get my account current, which
You look high now.
I'm not. I'm.
She's fresh off work, Your
I'm
Honor.
sending you for a drug and alcohol test right now. That's how you look right now. We'll see. I'm sending you for drug and alcohol test now. As it stands, they want to withdraw from your case.
This is the turning point for this defendant. Judge Fleischer's tone drops from casual inquiry to absolute authority. The instant suspicion about possible intoxication triggers an immediate drug and alcohol test. No delays, no debate. Here's why this matters legally. Bond conditions aren't static. If the court suspects you're impaired, the judge can modify your release terms on the spot. That means more oversight, stricter monitoring, and in some cases, pre-trial detention if tests come back positive. For viewers, notice Fleischer's body language here. Short sentences, sharper volume. He's broadcasting one thing loud and clear. I'm watching you closely. Question for you. Do you think instant testing like this keeps defendants accountable, or does it cross into micromanaging their lives?
Yes, sir. I'll have my account concurrent this week. I just got off of work. I'd worked overnight.
Where do you work?
I'm taking care of one of a friend's dementia grandmother.
How much money you make a month?
100 maybe, right as of now. I just got a second job, a serving job as well, so.
Who do you live with? Who do you live with?
I've been, since this whole case happened, I've been staying in like hotels, living, paying for hotels.
Is Anthony still here? Are you? Okay. I'm sending you for a drug and alcohol test now. You're not supposed to use anything whatsoever. So we'll see. It's up to you. If you want to withdraw, and we can find out whether she's going to qualify for another appointed lawyer. I don't know. As it stands now, I'm definitely sending you for a drug and alcohol test. Take a seat for me in the jury box.
Thank you, Your Honor.
You would still want me to
Yes,
grant it?
withdraw, please.
Okay, it's early enough that I will for you,
Okay.
okay? I want her drug and alcohol test right now.
Okay.
And then, Stephen, do you mind giving an application in the interim, please? It's Kizzy, it's on the docket today. I'm sorry, Mr. Rodriguez, how's jail?
Good.
Well, thing is that you were charged with assault, bodily injury. Now you've picked up a new case. I don't know what happened on either case. We're going to do probable cause. And so
And here we go. The chaos multiplies. Jonathan Rodriguez, already facing an assault charge, now picks up an interference with a public servant case. Translation: while cops were trying to arrest him, he fought back. Legally, this is a nightmare combo. Assault plus interference often signals to the prosecution that the defendant is volatile and resistant to authority. Judges see it as an escalation risk, which means tighter bond conditions or straight up jail time. Watch Fleischer here. He's not even angry. He's disappointed. That tone hits harder than yelling. He knows Rodriguez's chances are shrinking fast, and yet the defendant doesn't seem to grasp the gravity. Would you call this bad luck, or a pattern of reckless decisions stacking up?
on the assault, you're facing up to a year in jail and or a $4,000 fine. Now your newest case, you picked up an interference with the duties of a public servant. On that one, you're facing up to 6 months and or a $2,000 fine. We'll do probable cause on both, please.
Yes, Your Honor. So officers were dispatched to assault at a gas station in Harris County, Texas. So this video showed complainant, witness talking on the phone. The defendant approached the complainant, got close to his face, then swung multiple times with a closed fist, striking the complainant.
Just out of the random, out of the blue.
Should we go by the, should we go by the affidavit? Should we go by the affidavit, not the DA's breakdown? Because the DIM is a sworn affidavit.
I don't care. We can go by the Wicked Witch of the West, whatever stuff, you know, I don't.
Okay, Your Honor. So, fight continued to the gas station. Complainant was able to hold the defendant in the chokehold until officers arrived. So, complainant felt pain and sustained a physical injury.
So assault occurs allegedly. After that, the complaining witness gets him in a chokehold until the cops arrive.
That's correct. That's what's alleged.
So that's the assault. So what happened next? On the interference.
The new charge, the interference. On this particular case, on 5/24, of May 24th to 24, officers were dispatched to a disturbance call located at the address at 7505 Long Point Road, Harris County, Texas. Officer spoke with the defendant, Jonathan Rodriguez, who originally reported being assaulted. After the investigation was complete, charges were declined. But during the investigations, officers, it was discovered that the defendant had a warrant. And it was disclosed to the defendant that he had an outstanding warrant for an assault out of Harris County.
I'll give you your chance.
Upon being told that he was under arrest, the defendant became upset and said multiple times he would not place his hands behind his back. Officers tried to grab hold of the defendant's arms and attempted to place when the defendant pulled away and began yelling at officers, pushing, struggling, preventing the officers from getting him until they subdued him up against the car. He was finally placed in handcuffs and carted off to jail.
Got it.
This is where Rodriguez's situation goes nuclear. The moment officers told him about his outstanding warrant, his response wasn't compliance, it was chaos. Pushing, pulling, yelling, refusing cuffs, you name it. From a legal perspective, this single moment reshapes the entire case. Why? Because resistance eliminates credibility. Even if his assault defense had legs, prosecutors now paint him as someone who defies law enforcement. And here's the emotional gut punch. Rodriguez called the cops himself, thinking he was the victim in another incident, only to end up arrested on his own warrant. Imagine calling for help and leaving in handcuffs. What would you do differently if you were in his shoes?
Okay, Trinidad.
So on the first thing, the assault, the DIMS, the sworn affidavit, defendant that gets too close to the complainant's face while talking. The complainant then puts his hand out for the defendant to back up. So that means he had to have touched him. The defendant then
I don't know
began to
about
swing
that.
his arms. I mean, furtive motions, that's what we're looking at here for probable cause. It looks like, and then he ends up in a chokehold.
I'm saying, if someone puts their hand out, a reasonable response is not to start
I mean,
swinging.
close to his face. I mean, what are you doing?
Back away.
This is classic Judge Fleischer, cutting through legal jargon and speaking directly, almost like he's talking to the audience. Here's what makes this moment so engaging. He's not reciting law, he's appealing to basic common sense. If someone raises a hand to create space, you don't escalate, you de-escalate. That single line captures the heart of the case better than any affidavit. Psychologically, judges know juries respond to simple, relatable logic like this. Fleischer isn't just ruling here, he's setting the narrative for how future jurors will view Rodriguez's behavior. Would you agree with Fleischer's take here? Or do you think there's more to the altercation than we're seeing?
Doesn't hurt to back away.
And the complainant witness is the baby's or his girlfriend's pissed off baby daddy. Who's
So he goes up, you know that there's gonna be an issue.
You gonna stand up. You're supposed
Mr.
to stand up.
Rodriguez, you know that there's gonna be an issue with just by virtue of who the person is.
Your Honor, I just want to say for clarity, the complainant put his hands to tell the defendant to stay away.
Did he touch him or did he just say, hey, man, back up?
No, he did like that. It just says he put his hand up, prevented.
He put his hand up like this. He didn't touch him.
How are we making that up, but we can't make up the other stuff on the other side, saying that maybe.
I'm not making up anything.
It's 50-50.
The other thing, all I know is that he's out on the lam.
He didn't know. He's the one that called the law on this new case.
This next case, that was.
He's the one that called. He didn't know that he had a warrant. He would have known that he had a warrant.
So it was a 2B. He didn't know, he had not been arrested, given a PR bond and then got out? Is that what you're
I
saying?
believe that's how it went down. And so he's calling the law about this new assault that he's taken, and that's how he gets arrested. That's when they run him for warrants, that's how they get him. So
That's not true. It's not true. He was given a general order bond on 4/16/24, and he didn't show up to his court date. So we issued a warrant for his arrest on 4/23. So homeboy calls the laws when he knows he's got a warrant out for his arrest.
No, he doesn't. He wouldn't have done. Okay, all right. Yeah, you're right. All right. This is the streets out here. Hey, Judge, this is the streets out here. This is true. But I'm just saying, I mean, the PC, I mean, I don't want, if he can do the rip right now, then we can talk to this other fella, baby daddy, to see if there's any issue.
I'm down. I'm
We don't have
down.
film, we
Had
don't have
nothing else to do. So when it dies down, when the line dies down, let's have Kevin go call him and find out what's going on.
Get a ruling.
On what?
Probable cause.
Yeah, I'm gonna find probable cause exists on both cases.
Thank you.
Yeah.
Probable cause is one of those legal terms that sounds straightforward, but carries massive weight. Here's the deal. By finding probable cause, Fleischer is saying there's enough evidence for both cases, assault and interference, to proceed to trial or plea negotiations. It doesn't mean Rodriguez is guilty, but it locks him into the judicial pipeline. This is where many defendants panic. Up to this point, there's hope the case might get dropped. But once probable cause is established, your options narrow fast. Fight it out in trial, negotiate a plea deal, or in rare cases, get dismissed later if evidence collapses. If you were Rodriguez, would you fight both charges or cut a deal to minimize damage?
Good morning, Mr. Uloa. How are you? Tell me what you got for me.
I don't have physical proof, but I have proof of my enrollment in GED. The GED class doesn't start
Do you
until,
think you were coming today to the beach?
no. I'm gonna tell you that the GED class doesn't start until next month. But I enrolled.
In this life, you are only as good as the proof that you have. If you don't have proof,
I have
you
pictures.
have nothing. So I would like you to get with Mr. D.
I showed
Show
them the pictures of it.
Okay,
My-
so-
As his attorney, Judge, I would refuse to be in this. My job is to represent, not to incriminate. So
has he not given you anything to show?
he's given me information on a line. It does not say Mr. Altroff has been enrolled in this GED. It doesn't say the specifics at all. It doesn't say anything about he has been enrolled. This is to certify that you have been enrolled. There is nothing of that nature.
What do you have, Mr. Uloa?
I have pictures of me filling out the application, and I have email saying that the school doesn't start until next month, which is July, which is in a couple of weeks.
Have you seen the document that says that school starts?
I saw that document saying that school will start at a later date.
You don't think it's legitimate?
I don't know, Judge, but I just didn't see anything to say that he had been accepted in the enrollment, which I thought that would be relevant to your.
The only thing I asked you to do was enroll into a GED program. That's all I asked you to do. Have you done?
Yes, sir.
I want proof. I will not take your word for it. So I will give you, 20 minutes, 30 minutes, somehow print it out, show us that you have proof. And if you need, you can email it to one of us and we can try to print out what you have and I'll take a look and I can call and verify.
Okay.
But I will call now and I will verify it. And I want to ask them and talk to them straight up to see if you have actually enrolled into the DED program. So please step down and give me the proof.
Thank you.
Thank you, Mr. D. Hi, yes, ma'am.
Good morning.
Hi.
I'm here on Mr. Keelan Felix. We were asking for a reset pending his felony, which will appear on June 21st.
Where's Mr. Felix? Come up, Mr. Felix.
There's also Jason Lucas, his higher attorney who passed. We, Mr. Romero. and
Hold on. Come up, Mr. Felix.
Yes, sir.
You picked up another felony?
I just came because we already talked about this. I did all my classes and everything. That's why you put me on the monitor. I think everything.
Have we addressed that he picked up the new
I'm
felony?
not sure if that was a question. I wasn't sure.
Came 2 weeks ago. Yes, since we have the felonies, he's coming to our office today to.
Well, no. He has already a lawyer in this case now with Connor, who's been representing him. So who do you work with?
Mr. Rodriguez. Romero says it's good.
Okay, are you signing on to this case?
That's the idea, yes.
Are you sure? Do you want to reach out to Carlos first?
Yes, an idea is kind of in his hands rather than our hands.
Well, I don't know. I would,
The firm's aware of it. It's just Mr. Felix, whether he wants to go forward.
I don't know. You want to reach out to them to see if in fact that you want to sign on? Because he's got 3 cases with us now.
Yes.
Or I think, no, just 2.
It's 3. One's a deferred judge. It's running concurrent with a 262nd deferred as well. And they haven't filed an MAJ yet, but there's a note that it's about to happen. And I don't know if there's one in this court yet.
Did you hear that? Did you hear what he just said? Any minute, they're about to issue a felony warrant because you're on probation in your felony case and you've picked up 3 cases since then.
I didn't pick up 3 cases. I was on probation for it.
I'm just telling you what the prosecutor said. That's all I'm saying, you know? So, I don't know.
I'm okay with the public defender staying here for today. We can just ask to go with us if you come.
Okay, take a seat through in the jury box, Mr. Felix, please. You know where Connor is? I mean, he's still here, right?
He was in and out. He's got a couple more cases.
Okay, great. Okay. On the, so we are going on the 2507-393?
No. Oh.
Okay. Good morning, Mr. Gutierrez. You're now charged with 2 DWI seconds. You know, the only thing that we want in our country, we want our streets to be safe. Do you know that Harris County leads the nation per capita in DWI fatalities?
This is the moment the entire courtroom stops breathing. Fleischer delivers a gut-punching fact. Harris County leads the nation in DWI fatalities per capita. Suddenly, this isn't just about one man's mistakes. It's about public safety. Judges don't drop stats like this for drama. They're making a moral argument. Fleischer is saying, this isn't just your life at stake. It's everyone on the road. Viewers, here's a reality check. In counties like this, repeat DWI offenders are treated like ticking time bombs. Sentences spike, bond conditions tighten, and sympathy, nearly zero. Would you support harsher penalties for repeat DWI cases, or do you think rehabilitation should come first?
Guys, keep it down, please. We lead the nation in fatalities. And here you are charged with 2 open DWI seconds. What is it gonna take to get through to you? Is it someone dead where you go to prison for 30 to 40 years? Is that what it's gonna take?
The one that,
Understand that if you ever come back to this country and you're in a car driving and you get pulled over, an officer is going to see DWI, DWI, DWI. If they smell alcohol, what do you think they're going to do to you?
This is Fleischer's fury, unfiltered. He lays it out in plain English. Another DWI = automatic prison time. No bargaining, no leniency. Here's why. Repeat offenders create predictable danger. Judges often feel morally obligated to protect the public, even if it means throwing the book harder than before. From a content perspective, this VO is pure viral gold. Fleischer's booming delivery combined with the defendant's blank silence creates a tension you can feel through the screen. What do you think? Is this tough love approach necessary, or does it risk ruining lives instead of rehabilitating them?
¿qué crees que va a hacer él? ¿Qué crees que va a hacer él?
He said, me va a castigar.
He's gonna punish me,
Pero yo ya no pienso volver.
but I don't think I'm gonna come back.
I didn't hear you. We'll get there. But if you're caught in a car with alcohol on your breath, what do you think officers will do to you when they see your record?
Es cuando vean el récord, que te vean que estás borracho, ¿qué crees que van a hacer ellos?
Me van a meter a la cárcel.
You're gonna go to prison.
Not jail, prison. From now on, because of your history, you'll be facing a minimum of 2 years in prison, a maximum of 10 years in prison. Not only that, you're now being deported to your country of origin. If you come back, the feds can hit you with an illegal re-entry, and then with that, you're looking at a minimum of 5 years in federal prison on that one as well. So I would be very careful.
This is where the stakes shoot from state level to federal. By tying illegal re-entry to potential 5-year federal sentences, Fleischer reminds the defendant and everyone watching that immigration violations layered onto repeat DWI cases are an entirely different beast. Legally, this warning matters because defendants sometimes don't grasp federal implications. They think resolving the state case ends it. It doesn't. The feds can come knocking later, and when they do, sentencing is harsher, faster, and less negotiable. Would you take this as a wake-up call, or would you roll the dice and hope never to get caught?
If you come back, how you come back. Because you could be the next time be facing a lot of time in prison. The only thing we want are streets to be safe. That's all we're asking to do. If you're gonna go drink 15 beers, find another way home. Don't drive. Do you understand?
Yes.
Guys, keep it down. I'm not asking for much. You give up a lot of rights by entering into this agreement, Mr. Gutierrez. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, you can never change this. Like I told you now, you will be deported. If you come back illegally, you could be facing a lot of time in federal prison. So I would be very careful. Not only that, you get into a car with alcohol, you're going to be facing even more time with up to 10 years. How do you plead to this offense, sir? Guilty or not guilty?
Guilty.
I will find you guilty, sentence you to 60 days in jail. I'll give you credit for the 30 days, the 32 days that you've done. I'm going to suspend your license for 2 years. Don't drive.
And finally, Fleischer slams the brakes. Literally, a 2-year license suspension isn't just an inconvenience. For many defendants, it's life-changing. It affects employment, family logistics, and even mental health. But here's the kicker. Statistics show over 30% of suspended drivers end up driving anyway, which creates new charges and drags them back into court. Fleischer knows this cycle well. That's why he hammers the warning. If your license got suspended today, Would you comply fully, or would you risk it just to get by?
Don't drive. Okay. Oh, hold on. Roberto, case was enhanced.
No, preguntar si es cierto o no es cierto que tenéis un previo para decir si es cierto.
Is it true or untrue that you had a prior DWI from 2015 here in Court 5?
Es cierto, no es cierto.
True to the enhancement. Okay, good luck. Connor. Hi, bud.
Hey, so, approaching on Keelan Felix, apparently,
Where are we with this case? Because I don't remember.
so we picked up, me and Pavel were talking about a plea and we talked about trying to work it out, because he does have, a UCW and, the prohibited weapon.
Hey, we didn't address the new case though, did we?
He was in custody for a while. Yeah, I mean, we addressed, the UCW new case. He does have the felony, new case as well. But I was appointed last Saturday.
I never revoked, I would have revoked his bond on the new gun case with us after he would have picked up the felony, and I never did that. That's what, like, come up.
I think, Judge, I think you did revoke the bond. You said it at 3,001.
Let me see, let me make sure. Yeah, yeah, I did, because it looks like he posted a surety bond on 5/9/24. So Connor, the question is, what do we need to do to make sure that Mr. Felix doesn't have a gun in his possession?
Judge Fleischer's frustration peaks here. This defendant, already tangled in multiple felony gun cases, is still finding ways to end up in trouble, and Fleischer has had enough. From a legal standpoint, this is high-stakes repeat gun offenses signal to prosecutors that bond alone isn't enough to keep the public safe. That's why Fleischer hints at escalating restrictions, monitoring, and possible custody if another slip happens. What's striking here is how personal Fleischer's tone gets. It's less about the law, more about trust, and the defendants burned it one too many times. Would you side with the judge here and push for stricter measures, or do you think Fleischer's leaning too hard?
Because apparently 3 open cases is not enough, and a bond of nearly $42,000 is not enough. So what do we need to do to make sure you ain't got a gun in your hands?
Sir, I'm doing right, sir. I just did the classes and everything that you told
Talk
me.
about you doing right. You picked up a felony gun case on 5/2.
But it wasn't even mine.
Perception.
I'm staying out of trouble. You just put me on this monitor. I'm being watched. You just put me on the monitor 2 weeks.
Is it uncomfortable?
I mean, yes, but I ain't really
Oh, I'm
tripping.
so sorry, Mr. Felix. Better than being in jail, right? Okay. You're lucky you're not in custody right now as it stands. And I'm gonna tell you now, you ever pick up another case, you ever have a gun, I'm gonna make your bond so high, you're gonna split in quads.
This isn't just a warning, it's a nuclear ultimatum. By threatening an unreachable bond, Fleischer effectively tells the defendant, one more mistake and you're done. Legally, judges have discretion to set sky-high bonds when they believe defendants pose public safety risks. And with 3 open cases already, Fleischer's message is crystal clear. The system's patience is gone. From a storytelling angle, this VO hits hard because it blends authority, emotion, and stakes in one punch. If you were facing $42,000 in bonds already, would this warning scare you straight, or would old habits still win?
What's more is I'm telling you, I'm going to drug test you soon. If I find that you're using anything, you know what's going to happen. Now, the question is like, he's got with us, he's on probation he's on deferred for a gun, for discharging a firearm. And then he picked up the gun case with us in December. And now the gun case upstairs, I'm not gonna hold it open forever for the new case to play out upstairs, you know, so.
I'm
Tell me.
prepared to move forward without it. The thing is, I mean, it's up to you on what we do with this probation. The UCW is an under 21 case and he was 4 months away from being 21. But the probation, Pavel and I talked about doing a time served, just unsat terming is deferred.
And then pleading under the new one?
We didn't talk about the UCW.
New one.
Yes, sir.
So let's do this. Let's set it off just a couple weeks. Have you gotten all the evidence in the new case?
Yes, sir. Yes.
Have you gone over it with Mr. Felix?
I can't, no, I haven't, I mean.
So let's do that. I'm setting your case off for a couple weeks. I want you to meet with Connor to go through all the evidence, and then we're gonna work something so that these are done, so that you can concentrate on what happens upstairs. Okay? The worst thing you could possibly do is pick up, even go near a gun. Don't. Now, what are you doing for a living?
I'm down bad right now. My little, somebody just hit my little brother in my car.
Hold on. Are you truly working? Or you just spitting out?
No, I work with my uncle.
What does that mean? I work with my uncle.
From time to time.
Okay, from time to time. So that what? Come on, give it to me straight, Mr. Felix.
It ain't just, no, it ain't no, it ain't, it's just like when he called me, it ain't no everyday job.
Then you must now get an everyday job. I'm resetting your case for 1 week. I want you to see what you've done to get a new job. Go to Amazon. They hire everyone.
I did the class and everything though, that you told me about. I got you, Mr. Fleischer.
The problem is, Mr. Felix, when you have too much time on your hands, you become self-destructive.
This is one of Fleischer's most quotable lines yet, and it cuts deep. The defendant claims he's doing fine, but Fleischer spots the pattern: no steady job, idle days, and repeated arrests. Psychologically, this is brilliant judicial strategy. Fleischer reframes the problem as lifestyle, not luck. He knows staying unemployed and unstructured keeps defendants trapped in cycles of chaos. Notice the audience reaction here. The courtroom goes silent. This isn't just a lecture, it's a wake-up call. Would you agree with Fleischer here? Does too much free time really push people toward bad choices?
That's what's going on. You don't do a darn thing in life, and the problem is that you get caught up in doing because you ain't got no job. J-O-B, that's the word of the day.
Yes, sir.
Are you unable to control yourself?
Yeah, but you make me nervous.
Good. I'm glad. I want you to get a job. In 1 week, you will be back here to prove to me what you've done. And if you have nothing, it's in my email. If you've done nothing, it's not gonna go well for you. No buts. Get a job. Start looking. When you have too much time on your hands, you become self-destructive. Sometimes we have to save people from themselves because they're our own worst enemy, and that's what's happening. That's what's happening with you. You are your own worst enemy because you have too much time on your hands. The nice thing about working is not only does it keep your time occupied, but you get money too. And you get to buy nice things like cars, houses, jewelry. Get a job. Got a week to show me what you've done. You're not here going to the beach, so bring proof. That means paper, not palabras or words. Thanks.
Judge, would you be okay with doing a time served on his probation case and unsat terming his deferred?
I don't know yet, because I want to make sure that he's first a working man before we just start pleading and putting more stuff on his record, thereby making you unemployable. The more stuff you pick up, all you're doing is you're making yourself no one is going to give you a job when you keep racking up convictions. You don't get it. The next 40 years of your life can be amazing, or they can be a rotten toilet of an existence.
Talk about gut punch imagery. Fleischer isn't pulling punches here, he's forcing the defendant to look decades ahead. Every decision now stacks into a future that's either built or broken. From a content perspective, this is where clips go viral. The line is dramatic, memorable, and relatable far beyond the courtroom. Legally, this moment matters too. Judges don't just rule, they influence behavior. Fleischer's warning isn't about the next court date. It's about avoiding a lifetime behind bars. What do you think? Do tough love wake-up calls like this work? Or do they fall on deaf ears when someone's already spiraling?
Mr. Felix, and what you're doing now, have you looked in the jail?
Just died like two, 3.
Take a look at how many old people in there. There's a reason, because they ain't got no job. And all they do is they keep pleading guilty. Stop it. You got a week. Thanks, Connor.
Oh, I think we're talking about the thumbs up.
Hey, can you send her for a drug test, please, before it gets too late? Yeah, can we send her now before it gets too late?
Update on Escobar. He's on attempts to now, but that's another first attempt.
Okay, all right. It's okay, this way, guys. Travius Miller. Mr. Miller, you are wanted out of the state of Georgia for aggravated assault and terroristic threats and act. Are you waiving formal extradition, sir? Okay, we wish you the best of luck.
Hey, Judge.
Thank you, sir.
Could you explain me the process to me?
So what happens is you have an open warrant out of Georgia for both of these cases and they want you. So we give them the opportunity to come and get you. We give them 14 days to come and get you. If they don't get you by then, the DAs file a motion to dismiss and then they release you. But understand that just if they release you because Georgia doesn't come for some reason, which they probably will, but if they don't, the warrant is still active. So as soon as you walk out of jail, they can still pick you up and bring you right back to jail because you.
But not in the jail, but on the corner, that's what you're saying.
Right, right. I mean, you have this warrant open until you go back to Georgia and take care of it. So for the rest of your life, if you never go back to Georgia to take care of it, it's going to be open forever. Okay. But they're coming, right?
Yes.
Georgia has already indicated that they're coming to get you. Okay? Yeah.
Judge, on Mr. Vargas, we're ready whenever you are.
Okay. I lost my translator.
I'll text for virtual again.
Please. Yeah. Hey.
Hey, Judge.
Come on.
I got Brittany Gillardoni. She had a bond forfeited. She's back in custody. She's got a $10,000 bond on her TCS, deferred adjudication upstairs.
Hold on. Let me look it up.
Yeah. Well, what I'm getting at is I had done a competency psych eval. She jumped on, so that was never done. I did see, though, we did see that the felony court has requested one as well, but that hearing is not scheduled until like end of July.
On in our case?
Well,
tell me they gave her a PR bond. Oh,
well, she's not in the holdover.
$7,504 PR bond.
No, cannot believe that.
She's not in the hold. Well, unless I missed her, I checked in here in court. Gillardoni.
She's here. You must have not answered up to you, but she's here.
She's back there?
She's on the other side, Court 8.
She wasn't. Oh, Court 8.
I'm gonna say.
She's in Court 8.
And I mean, they gave her a PR bond. I can't. She's a super flight risk.
Well, she's not getting out, the felony, just.
Nevertheless, and perhaps that's
Okay,
why.
so do we need to bring her over to, I mean, what are you doing?
We got her, so she's on Court 8 side.
But I never.
I'm bringing her, please.
But she never got psyched on my request, and then.
Let me.
Was what she did. It was that she was previously found competent and then she absconded afterwards, but for some reason the felony court have re-requested evaluation, I guess because of the absconding and the fact that they didn't have it in their court. So they made a motion and it was granted by the judge up there, and they just haven't set a date for that competency eval.
Have they set a date or no?
No, they just filed the motion, it was approved, but if there's a date, it's not in the notes.
Oh, I was in the wrong court, so I was in Court 6. That's my bad, I thought they were attached.
Right. So she's, for us at least, she's taken off on 3 different occasions, you know?
Okay. And then I do have a trial setting Friday at ERD, but it's going to plead today. I don't know if you need to know that.
No.
Okay. Just taking it deferred.
It's with us?
It's in your court, yeah.
Is it?
Ovalis, Sharice Ovalis. It's on docket today. Okay. I'm just letting you know. I don't know if it.
Yeah.
Just letting you know in case I take the jury there and then it comes here. I don't know how that works.
Tony, as soon as I get a translator, I'll hit you up, okay? That's the only thing we're waiting on.
No problem, Judge.
Wait, do you want, are we setting it or is he taking a deal?
Yeah, I think we're more than likely going to set it. He's telling me that he might need to get operated on though. So I don't know what the time frame is on that. So let me verify that real quick.
Yeah, I mean, I'm setting it for trial now. I'm not gonna sit here and wait because I don't know what kind of game he's playing. All I know is that's 400 days and I'm gonna set it.
Okay.
You know,
Over there in civil,
it's always something.
5 minutes ago. He said he filed it.
Yeah, but they said it's.
So if he does want to take something, let me know so we can get the paperwork written up so you don't have to wait even longer, you know?
Yeah, you filed it wrong and.
Need stipulation, right?
Wait, it just needs a stipulation or the whole thing needs a refile?
Sorry?
It needs just a stipulation or a whole refile?
No, I understand right here.
Step forward.
The felony is holding you. You have a $10,000 bond, and apparently okay, well, hold on, because judge needs to talk to you.
Yes, Good morning.
So I wanted to bring you out because, you know, we're talking about your case. It's only fair that you hear what's going on, okay? Right now, you're on probation for a felon in possession of a weapon. You're also on probation for possession of a controlled substance in the felony case. You picked up in April with us, you picked up an assault bodily injury. You have literally been given 3 PR bonds and you continue to take off.
I didn't get PR bond, sir.
But you have. I'm showing that you failed to appear 516.
I just got a PR bond, sir. Excuse me.
Listen to Dave.
So Roberto, please don't go. Okay, so I have 3 different occasions that you failed to appear. I cannot, in my good conscience, give you a PR bond when you continue to take off because I know if we give you another PR bond, what's gonna happen?
I haven't had a PR bond, sir. I bonded out, and it's the only reason I'm back right here, right now, sir, is because someone took their name off the bond. I haven't did anything else and gotten in trouble. Someone just took their name off the bond because I couldn't get a cosigner. That's the only reason I'm back in jail right now.
I also have that you have failed to appear on 3 different occasions. Okay,
I haven't.
so so what we're doing, regardless, your bonds are set at $55,000 upstairs.
And I'm gonna make the bond this Saturday. That way I can take care of this stuff
You
better.
make the bond, I am now going to make you wear a GPS monitor so I know where you are at all times, okay?
Yes, sir.
But I cannot give you a PR bond in this case, okay? Because you just don't show up when we ask you to show up.
This is a massive turning point. PR bonds where defendants are released without upfront payment are built on trust. And this defendant has blown that trust repeatedly with no shows and new charges. By denying another PR bond, Fleischer forces him into a financially higher stakes situation. Without compliance, defendants risk jail until trial. For the audience, it's a stark reminder. The system gives you lifelines, but they're not endless. Do you think courts should stop offering PR bonds to repeat violators altogether?
So regardless, you have Greg representing you now. If you do get out, please stay in contact with him. If you get out, you post bond and you jet on me again, Ms. Gilardoni, I'm going to triple, if not quadruple the bond.
Thank
You
you,
understand?
Judge. Yes, sir.
All we're asking you to do is show up.
All right.
That's it. And stay out of trouble.
All right.
Okay?
Yes, sir.
I know that the felony courts are trying to have you evaluated as well. Do it, because if you don't, the only thing it does is it prolongs your case even more.
Okay.
Okay?
Yes, sir.
I think that we're okay. I don't think that there's.
Oh, you are. Thank you.
Yeah. So,
I don't think the I'm not showing a felony court date for her, but then I was showing,
I am showing 7/29.
okay, you got that 7/29 felony.
Your court date for your felony cases are July 29th.
Yes,
Okay.
sir.
We don't do that long. Okay, we'll do just 30 days and then we'll come back and then go from there.
Okay, Your Honor, perfect.
Thanks, Steve. Appreciate it. All right, good luck, Ms. Gallego.
All right, thank you.
Yes, ma'am. So, hey, please. Ixnay. Send them out.
That's my time served on the assault.
What is this?
18 days with 6 days, Rodriguez Jonathan, on the 865.
All right, good morning, Mr. Rodriguez. So is this what you want to do?
Yes, sir.
Understand that the assault will go on your record. The only problem is they cannot enhance this to a felony because it's just a garden variety assault, but you will be facing a minimum of 90 days in jail if you ever pick up another assault. So I would be very careful.
Sir.
You give up a lot of rights by entering into this agreement today. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. This is a final deal today. You can't come back tomorrow and say, you know what, I changed my mind. I want to do something different. It's final today forever.
Sir.
This is what you want to do?
Sir.
How do you plead to the offensive assault?
Good, sir.
I will find you guilty. You're facing a year in jail and or a $4,000 fine, but you guys have worked out an agreement where they're offering you 18 days in jail, credit for the 6. So it's basically, as part of the agreement, the other case will be dismissed as well. Okay, all right, good luck. Thank you, take care.
Thank you.
Okay, thank you, sir. 29. Hmm?
3 days.
Okay. He's got 3 days credit, Tony. You want to do 3-6 or 6-3?
That works, Judge.
Or whatever they offer, I guess. Hey, Kevin, do you mind writing up Vargas for a plea? He's got 3 days credit, so, 6-3, I guess.
No, look, Judge, the only thing that he had sent to the probation office and she didn't receive it was that the next class for GED opens July 24th, something like that. Yeah.
He didn't sign up.
No, sir.
Goes with you.
I signed up, sir.
Come on this way.
Show, where is it?
I got the picture. I got the information that I filled it out.
Filling out something is not enough. You have to press send, you have to get a date, and then you get proof of confirmation that you actually have your name on a class.
This VO is all about personal accountability. The defendant claims they've signed up for a GED class but has no confirmation, no proof, no email receipts. To Fleischer, that's the same as doing nothing. From a legal perspective, judges need hard evidence to justify leniency. Intent means little without action-backed documentation. Here's where Fleischer's frustration becomes relatable. Think about how often people talk about change versus actually showing change. If this were you, would you have your paperwork ready or risk facing Fleischer's wrath?
That's what.
The classes are open until July.
Yes, the classes are open. Did you sign up the class and are you actively enrolled? Don't send them down.
Judge, case number is 242-3695. Judge, I wanted to see if you would reinstate the bond. This is the defendant who was on a DWI divert. They recommended a extension. She needs to pay restitution and have the portable. She has the portable, but just be in compliance with it. She hasn't blown dirty, but she missed some days blowing onto it. So
that means it's as good as blowing dirty. Come up, Ms. Rodriguez.
Judge, she did tell me on Friday she was here. I think she was a little late. We told her to wait outside and she misinterpreted by leaving. You were here Friday?
Yeah,
What time did you get here?
I got here a little late, I'm not gonna lie. Yeah.
Where did you think you're going, to the beach?
They might have, yeah, so she went outside and she thought.
Court starts at 8:30. It doesn't start at 9:02, 10:51.
I know, I just don't have a car.
Number one. Number two, you're on a program that is no tolerance. And now you've done several things that they should, in all reality, just kick you out. The most important thing is to make the other party whole.
But just to her part, they didn't give us the form. They didn't email me this form until last week, the restitution form.
Okay, so that you just got wind of it?
You just got it. I mean, literally, and it wasn't part of.
Did you know
It
that?
wasn't part of the deal to begin with. They actually emailed me in the middle of this because it was she hit Harris County sign, but it was in the middle of her being in it that they recommended restitution. We didn't get the form until last week.
Okay, how much is restitution?
461.
Okay.
So she didn't know about it when we started.
I understand. Okay, so fair is fair, and it's really not fair to really spring it up on you at the last second, but regardless, the contract says that they can amend it at any time to add additional things. So, you be careful what you sign. When you sign something, you must look and internalize everything you sign, because the document says that they can withdraw from this agreement without, for any reason, because they don't like the way you walk, for example, they can kick you out of this thing. That's what the agreement says. The other part of the agreement is that they can add additional things as needed throughout if they learn. In this case here, Harris County wants you to pay back the sign that was broken. I've never personally seen this happen before. This is the first time I've seen it, but that's what they're asking. So
this moment is pure legal education wrapped in drama. Fleischer explains how plea deals and diversion programs aren't static contracts. The state can add new restitution requirements, alter conditions, and tighten compliance mid-program. Most defendants and viewers don't realize this. It's a game-changing insight about how legal agreements actually work. This VO pulls viewers in because it blends practical advice with real stakes. Fleischer isn't just warning this defendant, he's teaching everyone watching. Would you sign a plea agreement knowing it can change later?
One of the things that you'll be required to do is pay back the $460 for the sign that was broken, okay? What else, Shatoria, was?
She did the SOP.
She did the SOP, she did the victim impact. We have no proof that she's completed effective decision-making, and we want her to be in compliance with the device in a few months.
My client's added that she did complete it.
Do you have proof?
I do on my phone, but there was 3 classes that I needed to do, and I did all 3 of them. And then one of the
I
classes.
don't understand. So you didn't do them, but you did them?
No, I did do them. And whenever I had to send over my certificate to my PO, he kept saying that he didn't get it, but.
You have the certificate of completion now? Okay, so we can have you email it to Shatoria, and then assuming that that's legitimate and looks good, then we'll give you credit for it.
She's scheduled to see him on Wednesday, the officer.
Well, but she's here now.
Oh, yes.
Let's take care of it now. I mean, why delay the inevitable, right? I will try to help you as much as I can now, as long as you did it and it's legitimate. If you did, then we'll give you all credit where credit's due. So,
So they were asking for a 3-month extension?
okay. So understand, part of the agreement is they want you to have and be in compliance with the device for at least 2 to 3 months. So is your device currently operational now?
Yeah, my last device, my car stopped working, so that's why I couldn't, I wasn't blowing on it, and then.
It was an accident, correct?
Yeah, but since I couldn't drive it, because they give you like a warning and then they shut off your whole car, you have to like tow it all the way back to Smart Start and then pay it off, but I can't drive the car.
Do you have?
Yeah, I have to.
Do you have a portable device now? Really?
Yeah, it's in my purse.
Right, and it's operational. Okay, so you are not allowed to drive any vehicle that doesn't have an interlock on it. Understand, if you're caught driving, I will sprout horns in the tail because I'll be so upset if you drive a car without an interlock. I'm telling you now, the worst possible thing you can do is drive a vehicle that doesn't have an interlock. Don't, because that in and of itself is a death sentence, okay? Truly, don't drive. I don't care if it's grandmother's car that you just found out from 15 years ago. Don't drive any vehicle that doesn't have an interlock. You understand?
This is high-tech accountability in action. The defendant's bond now requires an ignition interlock device, meaning they can't start a car without passing a built-in breathalyzer. Here's why this is so impactful legally. Interlocks create constant compliance pressure. One slip, one drink, and the device reports straight to the court. From a content angle, this VO grabs viewers because it's practical, invasive, and dramatic, the perfect formula for retention. Would you trust yourself to stay compliant under 24/7 monitoring like this?
I mean, because you're looking at me like I think that you are, so that's why I'm saying, don't.
My PO already told me I can't be driving without the interlock.
Can't. I mean, that in and of, for me, that kills everything instantaneously. So don't. As long as you remain in compliance, we will set you off. It looks like, Shatori, did she do everything? It looks like everything is done other than the, what about community service?
That was nice.
What is it?
Back then when we signed it, Judge, it wasn't one of those mandatory, you have to do it, community service. I think now it is, but back then.
I don't know. But you guys should, what do you think? Is it on there?
From the email I received,
It is
Judge.
on here, and it says 6 hours remaining.
Just from the email I received, it was just decision-making force and being in compliance, and that was from Brenda, who runs the.
She has 6 hours remaining.
I don't think they required it, but
I
I'll
mean,
check.
if any, I do go to a church and help out. I don't know if that's.
I'm okay with that. Really, just get proof. Get proof. Don't bring something on a bar napkin. Make it look legitimate, like on a true letterhead of a church that you're helping out and you're not getting paid for it.
Yeah.
Okay. And I'm okay with that. Okay. So for now, I guess, how long is it going to take you to get the money to pay back the restitution?
I just started working, so in a month. My parents.
How old are you?
My mom. My mom and my 3 brothers.
Okay. How old are you?
22, just turned.
Okay. This is the right step because I'm telling you, with the DWI on your record, it will become very difficult to get a job. Your insurance will skyrocket. And are you seeing now how difficult it is?
Fleischer drops a harsh reality check. DWIs don't just threaten freedom, they haunt your future. This isn't courtroom theater, this is life advice wrapped in legal authority. A DWI can trigger skyrocketing insurance premiums, employment rejections, and financial chaos for years. Employers pull records, and in competitive markets, one conviction can close doors before they open. For viewers, it's a chilling reminder that even minor charges echo loudly. Would hearing this wake you up, or would you shrug it off, thinking, I'll deal with it later?
It only gets worse. I promise. You're on the right track. Keep doing well. Keep the device from, don't get in lockout. And I think you're on the right path. Okay? So set it off 3 months, restitution to be paid off in 30 days. If you ever have any more issues, come back and talk to us. The worst thing you can do is just don't stop appearing. Talk to Brandon. Brandon will come to me if you have any more issues.
In the restitution, like, in a month, can I get it lower? Like, the, having to blow on the device?
No, you have to keep the device. That's the most important part as well, that you have the device. We need to make sure that you're not consuming alcohol.
I stopped whenever that day happened.
Well, everybody tells me it's little bunnies jumping in the woods when they're up here in court. And it all changes as soon as they walk out the door. That's why we have the device, to make sure that you don't Jekyll and Hyde us.
Yeah.
Okay? But you're close. You get 2 months, 3 months, and you're done.
And they are.
Just, okay? Okay.
Judge, so her bond, you did revoke.
Oh, I'll reinstate the bond. Okay, okay. Thanks, guys.
You need case number? Okay, thank you. Thank you.
I have a Joe Castillo at 49 to submit to his weekly testing on Mondays.
Okay.
Now, he did not check in with the bailiff. His appearance was not waived today. He's on docket.
Yeah. We had,
Do you want to test him today? or would
yeah,
you
if he's
rather-
over there, test him now. Yes.
He has 12 negative.
Okay, yep.
We'll test.
How's jail? How's jail? Tell me. Good. I'm glad that you don't like it. You didn't get the message last time, and I don't know what I need to do. I'm not gonna let you fail, Mr. Thomas. And if I have to continue putting you in there, I'm gonna do it until you successfully complete this thing.
This is one of Fleischer's most raw and emotional moments. He's not threatening out of anger, he's pleading from frustration. The message is clear. I'd rather lock you up repeatedly than let you destroy your life. Legally, this ties to deferred adjudication programs. Judges want defendants to succeed because failure often means automatic convictions. That's why Fleischer fights so hard here. Your freedom depends on compliance, not excuses. For viewers, it's powerful because you see Fleischer as more than a judge. He's a reluctant guardian. Would you take this as motivation or resentment?
I will not let you get a conviction on your record. You understand? I don't want you to fail, and I don't want you to end up with a conviction on your record. And if I have to continue putting you over my knee like a little child, then I'm going to do it. Because the last thing you need is to kill yourself at 20 years old. Do you know what you're doing now?
Sorry.
Do you know what you're doing? What you and Mr. Duong have, what you're doing? What are you doing? Tell me. Guys, keep it down, please. Speak up, man. Come on.
Arrest classes, community service.
Fees, and you gotta make sure you do it right. It's a defer. Cannot fail it. To have the hearing.
Sorry?
So I can make sure my record is clean, yes, sir.
That's the idea. But you have to fulfill things on your part for it not to end up as a conviction on your record. Why do you, what's wrong? I mean, Mr. Thomas, what's wrong? Tell me. You look all dejected like.
Just trying to understand, Darius. I mean, you and I spent a lot of time this morning. He just wanted to make sure that, so just talk to him. He's a very caring person, a very caring judge. We all don't want you to fail, Darius. Okay? So it's tough luck is what it is. Okay? So.
Just extra bad bills and all, just stand out the way, trying to stay clean. That's pretty much it. Working two jobs.
How do we know? How do we know? You know, you sound all nice and everything now, but when you get out of here, how do we know you're not going to turn? You know, that's my main problem, my main concern is that when you walk out of here today, you're just going to turn into old Mr. Thomas. I want you to understand that
No, you're gonna have to do.
So you've got the terroristic threat, the assault, the failure to ID. Self-control. self-control. That's what it's about.
3 words, 1 lesson. Self-control. Fleischer zooms out from legal jargon to human fundamentals. Every assault, every DWI, every skipped class. It all connects to one skill the defendant hasn't mastered. From a psychological lens, this VO lands hard. Fleischer reframes the courtroom, not as punishment, but as training ground. Comply now, learn discipline, or face a lifetime of spiraling consequences. For your audience, this hits emotionally. It's relatable beyond courtrooms. Everyone watching knows someone who's lost battles with impulse. Do you think self-control can be taught, or is it something people either have or don't?
What are we doing to make sure that you're gonna have a self-control? Is he taking classes?
Yeah, he's gonna have to take some. He's gonna have to take the fifth. He's gonna have
18-week bit?
Well, I haven't confirmed with him, but he's trying to go to either Gabe or somebody to get it down to the online, but he doesn't know for sure. So
who's they?
Damien, State. So
talk to Damien about it?
Well, I have, but he's trying to verify to take it from the 13 weeks down to the 30 to the online class, but he has to get clearance from
Right,
one
because
of
the
the.
default for DVD is it must be in person from the last I know.
Right.
But
Really?
Oh, yeah.
Because the problem is I don't want to set him up to fail. That's a hard thing. And
Trust me, Judge, I've been with him over explaining to him, you know, he's got 32 days credit, so they'll give him 90 days for sure, but.
no, I'm not going to let you plead guilty.
Yeah,
Because then you're hosed forever with an assault on your record.
He doesn't want that, Judge. The good news is he's adamant that he's gonna get it all together. I know he's been trying, and I told him he has my number, so we're gonna help get through this. But those are the only things that we can get from the state.
Hey, how do we?
I believe he needs permission from Mary, but again, I don't, from the.
Now, he needed from Chief either Gabe or, oh, I forgot the other one, but so he's trying to run around to get that confirmed.
I mean.
That's what Damien told me this morning, but Gabe is out of town in San Francisco, so he has to run it through the other.
Gabe,
yeah, Kabat.
I don't know how to pronounce his last name.
You know, Gabe. But anyway, he can't help because he's in San Francisco, Judge. So bottom line is he has to get clearance in order to make it a lesser bit.
Can we? You want to do it today and then perhaps modify the conditions later?
Well, yeah, I mean, he's prepared either way, which one, I mean, I told him he's gonna have to, you know, the worst scenarios, he's gonna have to take classes, you know,
Darius,
he's
right?
gonna have to.
The problem is the class they want you to do now. It's called Batters Intervention Prevention Program. It's a class where you have to attend in person once a week for 18 weeks.
This is where Fleischer gets unapologetically strict. BIPP, Batterers Intervention Prevention Program, is no joke. 18 weeks of mandatory in-person attendance. Miss one, you start over. From a legal perspective, these classes are designed to force accountability and address deeper behavioral patterns tied to violence. But here's the drama. Defendants often don't have transportation, steady schedules, or financial resources to make it happen, yet compliance isn't optional. For retention, this VO hooks viewers because it exposes the hidden struggles behind court-ordered conditions. Would you be able to stick to 18 weeks of flawless attendance?
It's a lot. Is that something that you can do? How do you get to point A to B? Do you have a car? No.
I have transportation.
How?
But for the bus.
Who do you have in your life that can help you out?
He's living with his aunt, Judge.
Right now, it's not like.
And one of the things regarding the course is if you miss one, you start over.
Have you talked to Aunt? Have you talked to Aunt?
Ann?
Aunt.
Well, in the past I have, but not today because I'm trying to get this wrapped up and get him out. And I thought, but yeah, for sure, I'm gonna have to make sure, you know, he's got, well, I don't know if he still has the job, but he had a very good manager that was willing to help him with the Burger King in the ward. So I'm hoping he can go back to that, but that's all he's got, Judge.
Try reaching out. Well, my computer's been rebooting for the last 10 minutes, and so now that I have it up, I can see who the other chief is and give a shout.
I mean, I think Damien understands the situation. I've shown him all the texts. He's trying to help, but I think his hands are limited.
Do you have access to a computer with the internet?
But that phone.
What about it? What about at Ann's house? Ann's house, does she got a computer at home? Well, no, so she has a laptop.
No, sir.
She doesn't have any computer at home?
She's older. She doesn't do it.
How old is she? Oh, Lord, man. So she's not even watching after you, man. She's too old to watch after you? How old is she? Okay, that's not old, man. That's me.
that's younger than me.
Your old doesn't have a computer.
She just doesn't really, she's not into technology. She's not.
The other option I was going to suggest is we do like an online BIP class, but if you don't have access to a computer, I think the only option we have is for you to do an in-person.
There's the library,
What else is required here besides the BIP?
I think just community service fees, Judge, and a donation, $100, which.
I'm not, he doesn't have any money.
They told me it was.
I'm going to waive all your fees, so you're not going to have to owe anything. You will have to pay for the BIP class though, because I cannot pay for that. If I could pay for it for you, I would, but I can't.
This is one of the most humanizing moments in the entire session. For all his fire and fury, Fleischer drops his guard and admits something rare. He wants these defendants to succeed. If he could, he'd fund their compliance himself, but the system doesn't allow it. This VO resonates deeply because it reframes the judge not as an antagonist, but as someone trapped in the same bureaucracy. Viewers walk away seeing the human stakes behind the robes and gavels. Do you think judges should have more resources to directly support rehabilitation?
I asked about the donation and he told me it was statutory. That was a new one on me today, Judge, but if you can waive it, that'd be great, because obviously the young man needs all the help that we can.
Pay for a BIP class for him?
Yes, but it's gonna be a while, so.
I don't care. I'll pay for the class for you if I can. All you have to do is show up. All you have to do is show up. I'm telling you, if you don't show up, to me, that will be a kick in the ding ding, and I'm not gonna be happy. I'm telling you that now. I really want you to do well, Darius. Don't fail me on this, because if you do, all I'm going to do is end up putting you back in jail over and over and over until you get it right.
And just like that, Fleischer slams the door shut. This is the no-nonsense moment where compassion meets consequences. Legally, it's straightforward. Deferred programs are privileges, not rights. Fail to comply and the court revokes leniency instantly. But emotionally, Fleischer's delivery has weight. He's giving defendants the clearest roadmap possible. Do what's required or I will end your freedom myself. For content, this is the perfect mini cliffhanger to hold viewers before the wrap-up. Would this ultimatum scare you straight or push you further away?
I don't want to have to do that. Do you understand?
Yes, sir.
All right. Are both of the other cases getting dismissed or what? Okay. You've got this great deal. Hey, the only thing I want is the BIP class. That's all you need to do is this class. If you can get this done quick, I'll take you off quick in half the time.
So yeah, it's required, 42,504. The $100 is required statutorily now.
Okay. The only thing, you have to pay that per the statute, but I'll take all fees gone. Okay?
The donation fee, he has to pay that one.
He has to pay that one, but everything else, no fees. Okay. If you ever have a problem, get in touch with Shatori and she'll help you out. Get in touch with Don. He will help you out. You can always come back and talk to me here. If you take off, I'm going to be so upset. Do you understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront, cross-examine your accusers. You give up the right to appeal. So once you accept this agreement, you're stuck with us forever. Understand you're entering into a contract with me, Mr. Thomas, until you either successfully complete this or you get revoked. I'm not going to do this. I'm going to ensure that you pass this thing. Do you understand? If you violate this thing, I'm going to issue a warrant for your arrest. I'm going to put you in jail, and we're going to see how on earth we can get you to complete this thing successfully. But that's what's going to happen. If we have to continue to put you in jail for a week to 2 weeks, at some point, you're going to get it. Do you have any questions? How do you plead to the offense, sir? How do you plead, guilty or not guilty? I will not find you guilty. I will wait until eternity to make sure you get this thing done right. Good luck.
Yes, sir. Thank you, Judge.
Thank you, Judge.
John,
Judge.
will you get Ann's phone number, please?
Yeah, of course. I have. One other thing, Judge, we've been waiting for Escobar all morning. He's still over there. Apparently, he's not done anything. I just need to.
Go. No, we should zoom in.
You
Go.
just reset him or something.
Well, no, I'm not going to reset him or something.
I'm just saying, like, if he comes back and.
I'll call you.
Yeah.
Let me make sure I have your cell phone. Hold
No,
on.
I'll be waiting.
Wow, I can't believe it's this late. Time flies.
All right, Judge, that's it.
All right, we're done. Thanks, Kevin. Good job.
Thank you, Judge.
Anthony, great job today. You did good. So what happened? She just no-showed today?
No, not that. She called in with adequate time, but I didn't get notice until 8:44. So
Okay.
usually when they contact the jails, which is where we have them collect the call outs for the day, they'll let us know by like 6:37. So I didn't get the email from like 2 other people until 8:44. So I was intending to. bring it
Turnover
today, but she
sucks
should
so
have been
much.
informed. Yeah. That's
You
the
know.
problem. Now, I don't know moving forward what will happen. I actually have a meeting about the new hires later today, so we'll see.
Well, good luck. I'd like to keep you.
If something was to happen, I would request to stay here just for a little and help you out before we.
For sure. That'd be great. Yeah. Until we can get someone.
You know, my preference is court. I deal with a lot with the supervisor all day, but court is nice.
Yeah.
It's a lot more structured. I appreciate it.
Me too.
But it worked out. So.
Yeah, great. So that's.
And that's today's docket. A whirlwind of weapons charges, DWI chaos, probation battles, and one judge's relentless mission to force accountability. Here's what stood out. Dixon's chase spiraled from a traffic stop into a felony storm. Johnson's pills exposed the razor-thin line between habitual offender and second chances. Rodriguez's resistance turned a simple arrest into a stacked nightmare. DWI offenders faced Fleischer's full wrath, from fiery speeches to 2-year suspensions. And through it all, one theme kept echoing: change now, or the system will change you. For viewers, today wasn't just legal drama. It was a crash course on how one bad choice can snowball into life-altering consequences. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns every week. And don't forget to hit the bell icon so you never miss the next explosive session inside Judge Fleischer's courtroom.